Hello, everybody, for this evening debate on Frontex responsibility. We have actually tonight a large panel of speakers, not less than six speakers, 2 present on site and 4 who will be online. May I ask our technical team if we have for the moment yet the 4 speakers online? Okay, so, okay. Thanks a lot. Let me also salute, as usual, the participants online. We never forget you, and we will come back to you as first persons who will have the possibility to ask questions or to make comments. So tonight we have this debate. I had prepared 1 page to project. That's it. If you can make it bigger so that people can see. So I have prepared that table that you can try to complete if you want. And you will see actually the types of responsibility of Frontex. And I have tried to make a list: political, legal, financial, civil, and criminal. In a second column, I have put who is responsible, Frontex and or one or another member states, the actors of the responsibility mechanism that are either internal to Frontex, like the Fundamental Rights Officer, or external to Frontex, like, of course, the Court of Justice, and then the sanctions that can be the conclusion of the responsibility mechanism, either against Frontex and or the member states. So you see that it's a quite complex issue, and I hope that after this debate you will have the possibility to complete at least some of these boxes. That's a good exercise. 2 very short remarks before we start. Everybody, well, many people, NGOs, and the debate is focused on the responsibility of Frontex. And actually, I don't think that this is the main issue. The main issue is the responsibility of member states, because either they act alone without Frontex coordination, either they act under Frontex coordination, but they are the main actors. So, of course, Frontex is a kind of symbol, but we should never forget that actually the most responsible actors are the member states. Second remark, and I finish with that. One hears quite often that there is a legal gap, that Frontex is not responsible, or cannot be responsible before an organ or a judge, and that there is impunity of Frontex. This is not correct. There is always a kind of responsibility of Frontex. What is true is that it is not easy to activate that responsibility. For instance, if you think about civil responsibility, who is responsible, Frontex and or the member states, and to which judge do you go, the European judge or the national judge? So it is not easy to activate Frontex responsibility, but there is never a gap and impunity. And certainly the issue of civil liability is the most complex one, but actually I don't think that civil responsibility is very often used and is very useful because it is an a posteriori sanction. And if there has been a refoulement, the most important thing is to prevent refoulement and not to punish refoulement with, for instance, a civil fine. So let's keep all those elements in mind in order to, I think, keep a good view of the issue. So very quickly, let me introduce the first speaker of this evening debate, and then I will introduce later on the other speakers. Izabella MAJSCHER from ECRE, who is also a specialist of the return policy and the return directive. Let me also underline that as we have 6 speakers tonight and we want to give you the floor, we limit the first statement of the speaker to 10 minutes. And when I say 10 minutes, it's really 10 minutes because I will use my phone, and inside my phone you have a chronometer. And the phone will ring, and then the speaker will know that it is time to conclude. So, Izabella, you are the first one, and I hope that you will be a very good example for respecting the time limit. Let me just add that you will present the conclusions of a study made by ECRE on Frontex accountability. Isabel, the floor is yours.
Thank you very much, Philippe, for this introduction. Good afternoon, all of the participants present this evening. It's a true pleasure for me to be part of this panel, and big thanks from the side of ECRE to have invited us to join this debate tonight. So yes, exactly. I will present our key findings and arguments and conclusions flowing from the paper titled Holding Frontex to Account. The key concept of this paper was to look at the question of Frontex accountability through the lenses adopted by the literature dedicated to international organizations, and in particular, accountability of international organizations. And the basic premise, as concluded by the International Law Association, is that, and I quote, "The power of an organization attains accountability, which is the duty to account for its exercise." So there is a relation between the power of an entity and accountability that it should be subject to. And in this way, it's true that the 2019 regulations strengthen accountability mechanism available existing towards Frontex. However, in our view, they're still not proportionate to hugely expanded powers, effective funding available for the agency. And the literature that I just mentioned typically divides accountability channels applicable to international organizations or other non-state actors into 4 categories: legal, democratic, administrative, and social. And also in our paper, we adopted this terminology because it's useful in classifying the measures, the mechanism which exist, and yes, and it just facilitates the debate and assessment. We did not look into so much in detail into the legal accountability, and I'm sure that Iftach COHEN is gonna look into it in more detail. In turn, we focus on non-judicial accountability mechanisms and channels available. And I will look at each of them in turn, focusing on our key recommendations for improvements of each of them. So starting with the democratic accountability. Democratic accountability typically refers to an oversight by the European Parliament or national parliaments. And the 2019 regulation does foster this accountability channel. However, it can still be enhanced. And here I'm going to mention just two or three key points. So first of all, the management board. Currently, it consists of representatives of each member state and 2 representatives from the Commission. And then, as regards the Parliament, an expert may be invited to the meetings of the management board, while, for instance, to compare, representatives of EASO or Europol shall be invited. Yet we also know that recently a practice has been developed to invite this representative of the parliament, which is of course a very positive development. However, to ensure that this practice continues, we would welcome and adopting, for instance, administrative decision of the management board, which would indeed provide some stronger legal basis for it, or in the future, once the regulation is open for revision, to really think about according a proper seat for the parliament at the management board. Now, number two, relation between one of the multiple relations, I would say, between the parliament and the director, executive director. So under the regulation, the parliament may invite the director to report on carrying out of his or her tasks, including reporting on the activities of the agency, the implementation and monitoring of fundamental rights strategy, and, for instance, annual activity report. And it is a very strong provision. In our opinion, the parliament should use it systematically to request the director to systematically or yearly submit annual reports, and would, of course, then open a debate at the LIBE committee. And besides the reports or the outputs, which are explicitly listed under the regulation, in our opinion, the parliament could use the same provision to request other reports from the director. For instance, reports on the number of complaints mechanism and SIR, so serious incident reports. And likewise, this provision could be even potentially used for the parliament to seek input from the director under the procedure under Article 46, so meaning the procedure under which an operation can be suspended or terminated when there are violations of fundamental rights. So this was point number 2 under the democratic accountability. And point number 3, it's a positive development. In January this year, LIBE committee set up a Frontex scrutiny working group to assess Frontex activities and its organization, including correct application of EU law, human rights, and transparency, accountability to the parliament. So it's a very positive development, and especially that the working group is seeking information beyond the agency sources. Now, let me pass to the second set of accountability mechanism, now under the heading of the administrative accountability. So administrative accountability typically refers to an oversight by quasi-judicial or quasi-independent bodies of mechanism. So like the democratic accountability, it was fostered under the 2019 regulation, but in our view, improvements can still be necessary. So first of all, the fundamental rights officer, who is the key of fundamental rights monitoring and reporting mechanism. I will focus on the effectiveness of his or her, but now it's his role or resources. So looking at effectiveness, we look at what is really the follow-up to his recommendations and opinions. And under the regulation, so under the Frontex regulation, the director should reply to FRO on how the concerns regarding potential violations have been addressed. And this is a strong provision, which is also supported under the management board decision, which says that if the recommendations are not sufficiently addressed, FRO should issue another recommendation. And if still this is not properly addressed, he should be informed about the reasons. So there are provisions, however, still, in our view, it's still not clear what really the follow-up should be to under the existing framework to FRO's recommendations. In our view, first of all, the director should respond to the concerns and recommendations within a specific timeline, then draw up an action plan to implement the recommendation, or alternatively explain clear reasons why recommendations was not taken on board, and then invite the FRO for some exchange of views. And then we also foresee the possibility for FRO to even make the situation public, for instance, via his annual reports, which now will be public. I'm aware of time, so I maybe skip or maybe just briefly say also about resources. So of course, the famous 40 fundamental rights monitors should be hired soon. They are not yet, but I think already 20 are almost hired. But even once those 40 are there, it's still just not proportionate to the for instance, amount of other staff and operations. And we propose using an indicator to calculate how many should be there hired in order to be able to fulfill their tasks effectively. And again, the force should be involved in the director's decision about this number of monitors. Then I wanted to mention a few points on the complaints mechanism, but I'm aware that Marta CJEU is going to look at it really in detail, so I maybe skip this point. So maybe briefly look at the serious incident reporting, which is, I would say, a third key channel, a scrutiny channel under the administrative accountability. So this is the mechanism under which deployed officers should report serious incidents, including fundamental rights concerns. In our opinion, so it should be definitely strengthened because it's now currently underused. So, for instance, there should be sanctions for the officers for not reporting. There should be a formal and transparent follow-up, and also FRO should be much more tightly involved. Now, very quickly towards about the third set of mechanisms, meaning social accountability. I would say compared to the first two sets that I just mentioned, this one is the weakest one. And so here definitely there is a broad scope of improvement. Social accountability generally refers to scrutiny by independent bodies, civil society organization, or generate transparency and knowledge of the public by the activities of an organization. So here we look at consultative forum, which of course does not completely match the definition of social accountability because first of all, it's not accountability body, it's an advisory body, and it has among its members only half coming from civil society, but yet we still here see possibilities for this body to enhance social accountability of Frontex. For instance, now under the new regulation, the director should inform the forum on the follow-up. Yes, 30 seconds, I'm finishing. And follow up on its recommendations. So here we think that this provision can be interpreted by the consultative forum as requiring the director to explain the reasons for rejecting the recommendation. And then the consultative forum can include the follow-up in its annual reports, which are now public. Transparency, quickly, it's a very problematic point compared to other mechanisms. And here we also see a role for the Fundamental Rights Office to vet the refusals to share information or restricting the shared information only to the person who made the request. So now, just to conclude, so there exist channels, there exist mechanisms which fall under these three categories: democratic, administrative, and social. Yet each of them could be fostered in order to be more proportionate to the hugely expanded powers of Frontex. And some of the changes indeed would require revision of the regulation, but some of them can be done by broadly interpreting the current provisions or eventually maybe just issuing administrative opinion or decision of the management board. Thank you very much for your attention, and I'm open to questions to clarify whatever I said during the Q&A part of the session. Thank you.
Thank you very much, Izabella. So let's now turn to Mrs. Corinna Ulrich, who is the head in DG Home at the European Commission of the unit Schengen and External Borders. And you probably remember the difficult dialogue that took place between Frontex director and the Commission, exchange of letters that were not so nice. So I'm sure that Mrs. Ulrich has very interesting things to tell her about the role of the Commission regarding Frontex accountability. You have the floor.
Yes, thank you very much, Professor de BRUYCKER. I mean, we are the Commission, and indeed, I'm heading the unit that is in charge of Frontex in the Commission. So we are Frontex partners. So it's true that sometimes our letters don't sound super friendly, but then administrative letters rarely are. And but of course, we are Frontex friend. I want to stress this from the outset. Now, let's perhaps go through a bit where we are with Frontex. We have, as Izabella mentioned, we have a new EBCG regulation since 2019, which put Frontex really on into a new setting. It increased the numbers to 10,000 border guards. Now, let's be clear, it's not 10,000 border guards that are working in Frontex for Frontex, but a large share are border guards seconded by member states, either for a couple of years, 2 to 3 years, or just for a couple of months for a specific operation to Frontex. So the standing core, so-called category 1 of temporary agents and contract agents of Frontex will be much smaller and will be a bit more than 1,000 people. And the rest kind of comes and only for specific missions or for some limited time. But nevertheless, of course, this is a big change compared to before. The budget, also in terms of equipment, has increased massively, and so have the tasks. Frontex now also has a big role to play in returns of illegal migrants. The tools have increased. The border guards can now exercise executive powers. So this is the first time that a body of the EU wears a uniform and can carry weapons. So this is really a game changer, and it's clear that indeed with this kind of different powers and kind of the size of the operations, a different kind of governance had to come into play. And this is what the 2019 regulation put in place, and this is what we are at the moment in the process of implementing in cooperation with the agency. Now, this is difficult, and it's new. As I said, it's the first time that EU staff exercises executive powers. So, of course, there is some need for discussions, and we don't always agree from the outset. But it is also clear, and our Commissioner Johansson, has stressed very clearly that with these powers, there comes a big responsibility in terms of compliance. Frontex has to be exemplary when it comes to complying with legal obligations, in particular also in the area of fundamental rights. Now, the new regulation gives a big, Izabella has mentioned it, changes a lot in the fundamental rights framework. We have this new fundamental rights officer. She was there already before, but now he has just joined on the 1st of June, and before it was a woman, so this is why I get mixed up. But now he has staff on the site in Warsaw, but in particular in future these fundamental rights monitors, who are the eyes on the ground, who really should monitor the operations and report back in case they see problems, also receive complaints from migrants on the ground and report back to the headquarters. Now, I can there directly react to one point Izabella mentioned. Yes, kind of from the outset, these are 40 people, but very soon the executive director will have to report on the use and on the needs of the office, and will have to evaluate whether more monitors will be needed in future. So this is not a fixed number for the next couple of years until the next review of the regulation happens, but this is something that needs to evolve in line with the size of the operations of Frontex, and of course also corresponding to the situation. If we see increased numbers of potential fundamental rights violations, of course, probably we should have more monitoring staff in order to have a better picture of what's happening. Then perhaps a word on the management board composition. Of course, this is always open to discussion, how this management board should be working. Now, there is, since 2013, I think, a common approach for all EU agencies. Before, we have, I don't know, by now 30, 40 agencies. And before, every agency had a different structure. Some had a management board, some had a governance board. In some, there was one seat for the Commission, in some there were two. And the mechanisms according to which they worked were all different. And the EU at some point said, that the Commission in particular, but also the Parliament, this cannot be, we need a kind of coherent mechanism of how these boards work. And this is the model that also the Frontex Management Board now follows since the 2019 review of the regulation. Now, of course, you can say Frontex is different from the all other decentralized agencies, but then all agencies say they are different. So, of course, you have to weigh this kind of, the particularity of each agency compared also to having a coherent approach. However, the Management Board is very aware that we need to strengthen the governance, and actually very recently it has taken a decision on a reviewed structure of the Executive Board, which is composed of the chair of the Management Board, representative from the Commission, and some member states, so that the Management Board now becomes more operational, also looking into all these governance and fundamental rights issues that have been discussed over the last couple of months. So this is where we are with the regulation. Now perhaps let me say a couple of words within my remaining 3 minutes on the different reports that we have on the table. We have received recently a report from the European Court of Auditors, and I understand that will be still presented later on. So I'm not going to go into any level of detail there. Just to say that the Commission welcomes the recommendations, and I think so does Frontex. There are actually a lot of things that we are already fixing, or the agency is already fixing, or has already fixed, because this report necessarily related to a situation under the 2016 regulation and could not everywhere take into account what has been changed under the 2019 recommendation and now while we are implementing this new regulation. So there are a lot of things, and that concerns, just to give two keywords, Eurosur. Operational picture probably doesn't mean anything to you. That's normal. It didn't mean anything to me until 1 year ago when I joined the unit. But it's a network of systems that gives an operational picture of the situation on the external borders, movements of vessels, but also incidents that happen, so that indeed you have a comprehensive view of what the situation on the external borders is, where the migratory routes are running, where there are problems, but also where kind of potentially many boats could be in distress. So in order that you know where to focus your attention, also to save people in danger. And the recommendations that the European Court of Auditors issued for this system indeed have now to a large extent already been implemented through the 2009 recommendation and an implementing act that the Commission adopted in April this year. But of course, the most important thing is, of course, the allegations of the pushbacks that came up last summer, and to which the Management Board reacted relatively quickly. I have to say the Commission pushed very hard to have rapid discussions on these allegations that were reported in the media. We asked for 2 extraordinary Management Board meetings and also asked for a working group that was then eventually set up in November last year, which issued a first report at the end of February and then a final report, first report at the end of January and the final report at the end of February. And on the basis of these reports, the Management Board of Frontex reached a couple of conclusions on the 5th of March. And I think these conclusions are very important because I think they address quite a few of the issues that Izabella mentioned. they ask for a revision of the Frontex reporting system, because the group, on one hand, looked at 13 incidents that had been reported in the media in order to see what happened. But we very quickly arrived to our limits of what we could really assess ex post what happened. Because, I mean, if you have pictures from an airplane, can you really say, an airplane that is flying over the scene, what happened at that moment exactly? It's difficult. And yes, I'm coming to an end. And at the same time, then you see the shortcomings of a reporting system when you look into this. And this is exactly what these management conclusions focused on, because as Professor de BRUYCKER said, I mean, of course, it is important to know what happened in individual incidents, and it's of course important to have kind of individual justice, but it's almost even more important to prevent that something happens in future, and to be sure that you have a system where incidents are reported properly, where they are followed up properly, where the right instances are involved, in particular the fundamental rights officer of Frontex, where you have a transparent process. I mean, if you come to the conclusion there might have been a violation, now, as again, Professor de BRUYCKER said, it's not Frontex that is in charge. Frontex coordinates under the command of the hosting member state, and often the hosting member state and Frontex have two different opinions. Difficult to clarify, but you need to have a transparent process in a place. How you deal with this? How do you follow up on this? How do you obtain further clarifications? If you don't obtain satisfactory clarifications, what do? I mean, you cannot immediately stop all operations. I mean, then Frontex probably could stop everything a couple of months from here in the whole EU if every unclear incident would lead to Frontex stopping operations. So we need transparent processes so that everyone knows what to expect, and we get as much clarity as possible, as much as transparency as possible, but also that these possible violations of fundamental rights are prevented, because you have these processes in place which discourages from committing any violations. I better stop here, given that I'm already over time, but I can reply to all questions this might have raised, of course, later on. Thank you.
Just to be clear, did you have another report that you wanted to mention that has not yet or will not be mentioned? We have the Court of Auditors, but the Ombudsman we will also hear.
The Ombudsman you will hear, and then of course a very important report, Izabella mentioned it, will be the report from the Frontex Scrutiny Working Group, which is due to come out mid-July, if I'm informed correctly, and of course which will then be an important piece to work, Frontex and us, to work on and to follow up on.
And that will be the report of the Scrutiny Group of the European Parliament.
Indeed.
So it will come at mid-July. Thank you very much. Well, let's hope that Eurosur will report about the shootings that took place a few days ago by Libyan coast guards against a boat of migrants. I don't know if you have seen the video that I have shared today through Twitter, but it is quite incredible to see what happened. So that's a serious incident that Eurosur could report. Now let's turn to Mr. Leo Bricat, who works in the European Court of Auditors that has just published a report, and actually something quite interesting, because the conclusion of the court is that Frontex is not enough efficient. So everybody, well, no, many persons, sorry, think that Frontex is building Fortress Europe and is really extremely efficient. That's not the point of view of the Court of Auditors. So it will be interesting to listen to you, Mr. Bricat. Thanks a lot for intervening.
Thank you very much. Good evening to you all. Obviously, I'll be sticking to our findings, and these are the collective findings of the whole court itself, as approved. I'm pleased to present to you our performance audit on Frontex. This audit was carried out upon the suggestion of the CONT Committee of the European Parliament within the 2018 Conference of Committee Chairs list. Our audit focused on whether selected key activities at Frontex were carried out effectively to implement European integrated border management and to support member states to prevent, detect, and respond to illegal immigration and cross-border crime. We reviewed 4 out of 6 activities, namely situation monitoring, risk analysis, vulnerability assessments, and operational response, covering joint operations and rapid border interventions. The audit covered the period from end 2016, when the new responsibilities came into force, until February 2020. To answer the main audit question, we addressed 3 sub-questions. Is Frontex fulfilling its 2016 mandate as regards the fight against illegal immigration? Is Frontex fulfilling its 2016 mandate to fight cross-border crime? And is Frontex well prepared to fulfill its new and expanded 2019 mandate? We have excluded return support by design because we acknowledge this is another key activity that accounts for a large portion of Frontex's budget, but it is being covered by another ongoing audit for which I am responsible that covers more specifically return and readmission, and it should be out just after the summer holidays, sometime in September. We have also excluded the respect for and the protection of fundamental rights in Frontex's activities, not because they are irrelevant, but because the distribution of roles, authority, and human rights responsibilities among Frontex and member states are so deep and complex and multidimensional that in our view such a topic would arguably require a specific audit. I would like to say that our audit was not focused on any individual member states. So rather than giving the impression that we are apologizing for member states, it was not part of our brief to audit member states. Our brief was very specific to gauge the effectiveness of Frontex's support to the member states as a whole. This was the request made by the Parliament and the request which we took on board in the scope and approach of our audit. Since its establishment in 2004, Frontex has experienced significant expansion in its powers and responsibilities, with its founding regulation having been amended 4 times, in 2007, 2011, 2016, and 2019, the agency, as already hinted in some interventions, has progressively expanded its mandate, its functions, and its budget. Suffice to say that in 2006, they had a €90 million budget. This rose to 330 million in 2019. And as far as staff headcount is concerned, although they stood at 749 in 2019, in 2005, they had 45 persons. In 2016, Frontex became the European Border and Coast Guard Agency, with a mandate to facilitate European integrated border management at the EU's external border. In 2019, Frontex's role had been further enhanced to an operational one, coupled with a significant increase in resources, that of introducing, as mentioned, a standing core of 10,000 operational staff by 2027, and an average annual budget of circa €900 million to cover the agency's much upgraded tasks and functions. The aim of this would be obviously to address the so-called capability expectations gap, resulting from the agency's dependence on the member states and Schengen associated countries for contributions in terms of border guards and equipment. As far as our audit is concerned, although other aspects of Frontex have been audited in the past, this is the very first time where the Court of Auditors has looked at how Frontex performs its key activities, as defined in the 2016 regulation. For this reason, we think the report is timely, since the last external evaluation of the agency was published not yesterday, but in 2015, and the 2019 regulation was approved without, underline the word without, any impact assessment. We also examined Frontex's preparedness to fulfill its new and extended 2019 mandate. During the audit phase, we visited Frontex as well as the Polish and Italian Border and Coast Guard as our sample countries for the land and sea border, respectively. We also met a number of members of the European Parliament at various stages of the audit. Our overall conclusion is that Frontex's support for member states and Schengen associated countries in fighting against illegal immigration and cross-border crime is not sufficiently effective. Our audit found that Frontex has not implemented its 2016 mandate, and as a result, we highlighted several risks that undermine the successful implementation of Frontex's 2019 mandate. You cannot have a successful 2019 mandate if you haven't yet fully implemented your 2016 mandate. It's logical. We've seen that the agency responded to its new responsibilities, unfortunately, in what we consider to be an ad hoc fashion, and only began to address its needs in a systematic way quite recently in 2019. As Frontex's role was significantly extended, the need for extra human and financial resources was anticipated, to be quite honest, to ensure the new objectives can be achieved. However, this audit found that there has not been a necessary evolution in terms of human resources, competencies, and the profiles, particularly in sensitive areas, like the areas of risk analysis and vulnerability, as was required for these particular areas. Moreover, the last external evaluation of the agency was published in July 2015. Although the 2016 regulation required Frontex's results to be evaluated by October 2019, the evaluation did not take place, as the agency's new mandate came into force in November 2019. All this shows that our audit was timely and objective. I'll try to sum up. We found that although a functional information exchange framework is in place to support the fight against illegal immigration, it did not function well enough to provide accurate, complete, and up-to-date situational awareness of the EU's external border. On the other hand, an adequate information exchange framework has not yet been established for cross-border crime, and this affects the capacity of Frontex and the member states to monitor external borders and, if necessary, respond quickly to any threats therein detected. Frontex activities were not sufficiently developed to provide effective support to member states and Schengen associated countries. Frontex found it difficult to use national border controls authorities reporting under the European border surveillance, apart from the fact that there are also legal constraints on using the data located on the pan-European system for risk analysis purposes. Moreover, it is unable to apply the common integrated risk analysis model applied by most member states. It is important to remember that risk analysis has been included in Frontex mandate since way back when it was first set up in 2004. So this was and should have been the core to its informed decision-making. Ongoing issues with data completeness beset the data collection process of Frontex's vulnerability assessment, even though member states should provide the information Frontex needs. As a joint operation, the deployment of resources to fight cross-border crime is not sufficiently effective in Frontex's day-to-day activities. The lack of information on the costs and the performance of its operations hinders it from reporting a clear picture and also to inform its decision makers. A mere description of activities, you will no doubt agree, is neither an assessment nor an evaluation. And all this will, in our view, affect the capacity of both Frontex and its member states to monitor the external border and, if necessary, to respond quickly. Indeed, a failure in one area of activity can have a negative impact on other areas of activity. We conclude that Frontex has not taken the necessary measures to adapt its organization to address its 2016 mandate. To be fair, it normally takes any agency several years to implement a new mandate in a mature fashion. This is definitely the case for Frontex's implementation of its 2016 regulation. However, the 2019 regulation before Frontex has had the opportunity to bed down the new practices introduced by the new previous regulation, risks hampering its implementation. Therefore, as such, at the expense of repeating myself, we consider that there is a significant risk that Frontex will struggle to manage, if at all, to carry out the mandate it received in 2019. In the short to medium term, there is a significant risk that Frontex and the national border authorities will actually end up competing and poaching border guards from the same pool of candidates. I will just mention one thing about member states. We did not audit member states, and the questionnaire cannot be perceived as an audit. But we did send out questionnaires to the other countries we did not visit. We only visited Italy and Poland. 81% of the member states that replied to our questionnaire anticipated that the 2019 regulation will impact their staff numbers, requiring additional recruitment and the training of new border guards, in the expectation that Frontex will recruit its standing corps from staff currently assigned to national border controls. We end up by making 5 recommendations to Frontex as well as the Commission, all of which have been accepted by our auditees. First, to improve the information exchange framework and the European situational picture. Second, update and implement the common integrated risk analysis model and secure access to other sources of information. Third, to develop the potential of the vulnerability assessment. Fourth, to improve Frontex's operational response. And fifth, to address the challenges posed by Frontex's new mandates. I welcome the fact that the Commissioner for Home Affairs, Mrs. Ylva Johansson, welcomed such a performance audit in her initial reaction to our special report at the end of a recent Council Home Affairs meeting in Luxembourg. Given that the European Commission would like to have an agency, I'm quoting her, that is efficient and well-functioning. And given, I'm quoting her again, that the Commission has given a lot of power, a lot of responsibility, a lot of money, and a lot of funding, resulting in very high expectations from Frontex for the tasks it needs to carry out at its external borders. I'm pleased to hear, even this evening, that some of our recommendations are being implemented. This way, when we benchmark Frontex again within the standard 3-year period, there should be no excuse about any of these recommendations not having been implemented, because they seem to be a work in progress. At least so we have been told reassuringly, and we know that in a positive way. I would like to conclude by emphasizing that our sole objective was to carry out a fact-based audit, not to give personal opinions. All this within the scope of our task, with the sole intention of helping Frontex actually strengthen its practices, but obviously to guide itself according to best practices. And I would like to take this opportunity to inform you, as I mentioned earlier, that on the aspect of enhanced cooperation on readmission with third countries, that should be something dealt with in a separate standalone audit in the coming months. In conclusion, Frontex's tasks at the EU's external borders are, in our view, essential for the fight against cross-border crime and illegal immigration. Nevertheless, we can conclude without any hesitation that Frontex is currently not discharging the duty effectively, and this is especially true and worrying at a time when Frontex is being given bigger shoes to fill. I thank you very much, and obviously at a later stage I welcome any comments, criticism, or questions that any of you, ladies and gentlemen, might have to make. Thank you for your attention. Thank you very much.
Thank you very much for this explanation. And we have the report of the Management Board, the report of the European Parliament, the report of the Court of Auditors, and we have also an own inquiry that has been launched by the European Ombudsman. And we have the chance to have with us tonight one official working in the office of the European Ombudsman, Mrs. Marta Hirsch, and we will be extremely interested to listen to what the Ombudsman is doing. And the Ombudsman is quite active because it's not the first time that it shows interest for Frontex. Please. Is there a technical problem? Microphone should be open.
I think it was. Now
Yes.
it's okay. Do you hear me?
Yes.
Wonderful. Okay, so first, thank you. Thank you for having invited the European Ombudsman. I have an honor to represent her here during this meeting. And indeed, I will try to speak about the investigation which is ongoing, but also I cannot not to speak about the investigation which we have just closed. And we closed it also a bit earlier because all these investigation facts, they are linked together. But to start, I think I need to say it. If this is our starting point in all these investigations, if individuals want to complain about the member state staff taking part in Frontex operations for violations of fundamental rights, they could use an extrajudicial remedy before national ombudsman with the mandate to deal with human rights complaints or another national rights institution dealing with complaints. If they want to complain against Frontex, the European Ombudsman offers an alternative remedy to hold Frontex accountable, of course, always in terms of maladministration. But at the first place, the European Ombudsman may help to clarify Frontex accountability and push it towards transparency. And in 2012, we opened the first initiative inquiry into Frontex mechanisms to promote and monitor compliance with its fundamental rights obligation. At that point already, we made we said this clearly, that in Frontex operations, all participants, either staff of Frontex or national staff, wear the same armband with the inscription Frontex. So the common perception would thus be that all concerns should be addressed to Frontex. And this is why the Ombudsman recommended at that time the establishment of a complaints mechanism at Frontex. And we recommended that Frontex fundamental rights officers should assist the complainants in identifying who was responsible for the violation of fundamental rights. Parliament turned this recommendation to law in 2016 regulation, which has been already mentioned. And after we have assisted the first fundamental rights officer in creating the ombudsman time processes of complaints mechanism, we have closely observed what is happening with the complaints mechanism. And in December 2019, with the new regulation, which further reinforces the powers of the agency, reinforces the mandate of fundamental rights officer, developed the complaints mechanism, the Ombudsman found that now it's time for her to intervene again. And actually, we intervened twice. In November 2020, the Ombudsman launched an ex officio investigation into Frontex complaints mechanism and the role of the fundamental rights officers. She was concerned that the rules and complaints mechanism were not updated since 2016, that only 69 complaints were submitted to the FRO, fundamental rights officer, since the complaints mechanism was created, and that so far no complaints about Frontex and staff were submitted. Our investigation is now closed. The Ombudsman did not make a finding of maladministration, but 9 suggestions for improvement, so thinking about the future. The Ombudsman made again the point that no accountability is possible without transparency. I will just mention 3 of the Ombudsman findings in this sense. They are all about how Frontex rules implementing the complaints mechanism should be improved. And we said in the Ombudsman decision that for complaints alleging violations of the rules and the use of force, for instance, Frontex implementing rules should make it clear which rules and the use of force are concerned, which specific procedural steps are foreseen in the complaints mechanism to deal with such complaints, about the failure to act, a new possibility for complainants, which certainly increase the possibility for individuals to hold Frontex to account. Such complaints require the implementing rules of Frontex should clarify what is meant by a failure to act, maybe giving examples. Finally, we said also that fundamental rights officer rules and dealing with serious incident reports mentioned by Izabella should be also made public together with the complaints mechanism implementing rules. But more importantly, the Ombudsman made 2 statements, which I think they are essential for accountability. First, the Ombudsman said that even if member states have exclusive competence to conduct investigations concerning violations of fundamental rights in Frontex operations by staff from their national authority, the fundamental rights officer is empowered to conduct investigations into any Frontex activity. And in doing so, the fundamental rights officer has a duty to draw attention to the wrongdoings by national authorities in joint operations coordinated by Frontex, and issue recommendations. Secondly, the Ombudsman said that the executive director of Frontex, I am quoting, who is obliged by law to cooperate with the fundamental rights officer, should seek to act on fundamental rights officer recommendations, and that the decision of the executive director and a complaint forwarded to him by the FRO, fundamental rights officer, may be challenged before the European Ombudsman. But the investigation into complaints mechanism is not our last one concerning Frontex. In March this year, the Ombudsman opened another ex officio into Frontex. This is still ongoing. And this investigation is precisely about transparency, accountability of Frontex, other mechanisms regarding fundamental rights apart from complaints mechanism. We wanted to clarify first the transparency of joint operations. As we know, each such operation is implemented according to an operational plan. However, the plans are not in the public domain. We asked Frontex how it could remedy this lack of transparency, and Frontex told us that it cannot disclose the content of operational plans due to the nature of the activity. Secondly, we had another issue. Frontex and staff will be able to exercise executive powers on the ground. We wanted to know which specific guidelines or instruction Frontex provides to their own migration support teams, how to ensure the protection of fundamental rights in these activities. And Frontex told us that indeed they have specific guidelines in the form of a handbook. However, the handbook is confidential, so no disclosure. In addition, we wanted to know more about the use of this ultimate sanction or dimension at Frontex disposal from Article 46 of the Regulation 2019. And we wanted to know in particular whether the views of an ombudsman, of a national human rights institution about the violation of fundamental rights could serve as a criterion to decide about the suspension or termination of its operation. Here Frontex replied in the affirmative. We think that certainly the FRO was on board in this reply. The reply is good to this question and very detailed. Finally, in our ongoing investigation, we came back to the issues of forced returns. Actually, back in 2014, we had a specific investigation concerning forced returns, mostly about monitoring of forced returns. And as you may know, many national ombudsmen act as forced returns monitors, either on the basis of returns directive or as national preventive mechanism. Anyway, this was an investigation from 2014. We made many recommendations at that point of time. Frontex until now did not comply with all recommendations, so we thought that it is time to ask again. And the Ombudsman in the current investigation came back to the publication of Monitors report on its website. We asked it whether Frontex could do it. Frontex didn't reply in the affirmative. They said just that they are in the process of preparing the public register of documents, but they didn't say that they would include reports of forced return monitors in this register. Also, another issue which we have with the national monitors reports, they should be sent to fundamental rights officer. We recommended this back in 2014. This is not always the case, and Frontex explained to us this could be because of the language. They said that they could accept all reports in all languages possible, not necessarily English, and they would try to clarify this with the national authorities. Finally, we are also concerned, as do many national ombudsmen, that the incorporation of return monitoring into the legal framework of Frontex may put into risk the independence of monitoring. For instance, we know that the agency staff could act as escort officers, and at the same time, the agency staff will be present on board as monitors of fundamental rights compliance during forced returns. So we asked Frontex how they could manage this issue, and Frontex told us that is not an issue because Frontex monitors, we found 5 fundamental rights monitors assigned to return operations by the fundamental rights officer, they told us. So these 5 fundamental rights monitors will act as forced return monitors in accordance with Article 8.6 of the Returns Directive, thus within the applicable member states monitoring system, I quote again. And tomorrow, actually, we meet with our national colleagues from national ombudsman offices who are dealing with migration and asylum issues. Many of them, they work as monitors, and we try to clarify this statement by Frontex. Well, so I just tried in this 10 minutes to speak about quite long history of our cases, of our investigations concerning Frontex, and specific transparency, accountability. Once again, while we started to help actually individuals, how they could identify against whom they could complain and where they could complain, and we push it, Frontex in the direction of complaints mechanism. And I am sure that this will function better with many concrete suggestions we made as regards the implementing rules and complaints mechanisms. The transparency is also essential. And here quite a lot of still should be done. This last investigation, the ongoing investigation about transparency accountability is not yet finalized. The Ombudsman did not come yet to the conclusions, but we are considering the next step in this investigation, which could be a public consultation or consultation targeting some civil society organizations. So at this point, I will end, and I am open to questions. Thank you so much.
Thanks a lot for this presentation. We see that the Office of the Ombudsman is extremely dynamic. And also it's quite interesting to notice that there is a kind of European network of national ombudsmen that is another interesting mechanism. Now we are going to look to the fifth type of control that about which subject can be the object, and I give the floor to Iftach COHEN, who is actually a representative of Front-Lex, which is not about legs, but about lex, the law, of course. And a few years ago, we welcomed one of your colleagues who had decided to send a complaint against the European Union institutions and member states in the International Criminal Court for what was happening in the Mediterranean. And you have really a lot of imagination, because this time you decided to bring an action before the Court of Justice. So everybody was wondering, how can you bring Frontex in the Court of Justice? Well, you found a way to what is called an action for failure. And I give you the floor for 10 minutes to explain us what it is exactly about.
Thank you, Professor. Very nice to be here with you. So Frontex has operated in the Aegean Sea region since 2006 through its joint operation Poseidon. During the years and along the borders with Turkey, countless violations of the prohibition on refoulement have been registered and reported by asylum seekers, NGOs, and investigative journalists. On March 1st, the Greek Security Council decided to suspend its national asylum system for a period of 1 year. An internal note produced by Frontex, the agency itself, and provided to the members of its management board, revealed that alongside this unlawful and unprecedented decision to suspend the asylum system, a all new policy was supposed to be implemented in the region. According to the Frontex internal note, new border control measures were introduced with a view to basically preventing new arrivals at all cost. On the very same day, the Greek government has decided to suspend the asylum system. It also coincidentally requested Frontex to launch a rapid border intervention. Notwithstanding the critical situation in Greece and the actual wording of Frontex's very own regulation, it took Executive Director Legeri less than 24 hours to approve this mission. Now, this new border control tactics, the suspension of the asylum procedure, the launching of the RABI operation in such a hasty way, also dictated a all new division of labor between Frontex and the Hellenic Coast Guard. Frontex was tasked and is still tasked with detection, interception, and the handing over of asylum seekers and refugees to the Hellenic Coast Guard, which in turn completed the pushback operation by either towing the migrants on their unworthy boats after usually removing the engine, and or either transferring them to other unworthy rafts, towing them towards the Turkish territorial water and abandoning them over there. Now, this unlawful tactics, this decision, which has no formal name, and the launching of the Rabbi operation constitute, as we claimed in our recent legal action against Frontex, a state, an unlawful state, and also organizational policy of widespread and systematic attack directed against civilians, asylum seekers, and refugees, and so amounts to crimes against humanity. Now, Frontex, and here I must disagree with you, Professor. Frontex is a complicit, but in the execution of this unlawful state policy, but it is also a legitimizer, a facilitator. It is true that the current state member, Greece, is very fond of this practice of pushbacks, but without the political, operational, and financial support of Frontex and the European Commission at large, Greece would have never implemented and executed such an unlawful state policy. Now, Frontex is obliged to comply by action or omissions with its negative obligations. And by that I mean that it should refrain from actively breach human rights, fundamental rights during its operations. And Frontex is currently structurally in an ongoing breach of this negative obligation, given the established division of labor between Frontex and the Hellenic Coast Guard, and also based on the well-documented, exemplary, well-documented pushbacks operation, not taking from a plane, but really like reconstructed in the most reliable way by Bricat in October 2020. And according to those reports, at least in some pushbacks operations, Frontex assets, the Romanian one more than any other, were directly involved in the second phase of the pushback operation. Now, Frontex is also obliged to comply with its positive obligation. Positive obligations means that it needs to take any reasonable measure in order to guarantee the protection of fundamental rights during its operation. Some concrete set of positive obligations are also stipulated in the agency's founding regulation. For example, reporting and monitoring obligations in relation to the proper implementation of the operational plans, but also regarding the compliance of the activities with the agency's fundamental rights and international protection obligations. Now, a cornerstone of this concrete set of positive obligations that are stipulated in the founding regulation of the agencies is Article 46. Article 46 provides that in the face of either persisting or serious fundamental rights violations, the executive director shall, I mean, he must, he has very little discretion if to do something, but a more wide discretion regarding what he can do. In the face of fundamental rights violation, the executive director is obliged to take one of the gradual and proportionate measures provided in Article 46, the withdrawal of financing, suspension, or termination in all or in part of the contested activity. Now, in the context of the agency's activities in the Aegean Sea region, there is abundance evidence of the occurrence of fundamental rights violations. The UNHCR documented and also formally reported both to Frontex that afterwards denied the fact that UNHCR has provided it with such evidence. And keep in mind that this is a practice of Frontex, really like misinterpreting legal norms and misinterpreting also communication between other reliable organs. So the UNHCR provided Frontex and the Greek authorities with proofs regarding some several hundreds pushbacks operations that took place not by accident since the beginning of 2020. And you should recall the decision taken by the Greek authorities on March 1st, 2020. Even the Greek Minister of Interior provided some members of the Bundestag information according to which Frontex acknowledges the fact that it was involved in some 132 interceptions. What do they mean when they say interceptions? Interceptions, a la Frontex, means altering the course of refugee boats, okay, without any individualized assessment. And Frontex claims, or tries to claim, after it was already, it felt the heat, that it can do so, notwithstanding the spirit and the letter of Regulation 646 from 2014. Now, Frontex is in constant, in a state of ongoing failure to act in accordance with its obligations under Article 46 by not taking none of the measures that were supposed to protect human rights during its operations. And it does so basically because in order to trigger Article 46, you need to be able, okay, to gain knowledge about fundamental rights violations, to acknowledge them. However, Frontex does not have a functioning reporting and monitoring system. And I've heard the other speakers giving Frontex the benefit of the doubt. It takes time to implement regulations and all. I will finish in 2 seconds, 2 minutes if possible. But this is not a trial run. Like, the lives and the rights at stake are of people that cannot wait for the agency to implement, to properly implement the new regulations and the obligations contained in it. So what Frontex does not have a monitoring and reporting system that function, as a culture of dishonesty, the culture that was alluded also by the commissioner as well, that talked about the old culture of the agency. We do know that the fundamental right officer, the one that was in office until a few months ago, said that there is a culture of retaliation against decent officers that wish to comply with their reporting obligations. All that brings about a state of affairs in which the executive director is a priori oblivious to the occurrence of fundamental rights officer, and thus he cannot apply Article 46. All that was the base of our recent legal action against Frontex for failure to act under Article 265 TFEU. Thank you.
Thank you very much. Could you maybe explain in one word, what do you expect, what will be the consequence if you win that case in the court?
This is a request for a declaration of the court, basically, to declare that at the time that we called upon the agency to act a few months ago, according to the jurisprudence of the Court of Justice, Frontex was indeed under the obligation, and we claim that it still is under the obligation, to take one of the measures stipulated in Article 46. Afterwards, if the court will deem our legal action admissible, which is of course the first stage that we should overcome or hope to overcome, the agency should of course correct its conduct.
Thank you very much for those explanations, and let's now listen to the last speaker, Professor Iris Goldner-Lang from Croatia. So we wanted to give her the floor, despite the fact that she is not acting at a European, but at national level, and in particular in Croatia. And we were interested by that and proud as well, because Iris is a member of the Odysseus network, and she has just been appointed as a member of the board of the new independent monitoring mechanism created by the Croatian government to control the respect of human rights, and in particular the implementation of the principle of non-refoulement. And we take that as a sign of openness of the Croatian government. It is the very beginning, as this mechanism has just been created, even before the adoption of the screening regulation, which makes it mandatory under Article 7 for member states to create that type of mechanism. So, Iris, could you tell us a bit more about what's happening in Croatia and your experience?
Yeah, sure. So thank you very much. Thank you, Philippe, for the invitation, and congratulations for this amazing program and for yet another successful Odysseus Summer School. So as you rightly stated, so I'll be talking about something a little bit different. So the independent monitoring mechanism that I'm now part of has been established in Croatia this June. So it's, I would say, brand new. And its aim is to monitor the conduct of Croatian police officers towards migrants and asylum seekers. And it has been established for 1 year with the possibility of extending its term of office. And its activities are to be implemented through a coordinating board, which consists of representatives of 4 NGOs and myself. And the 4 NGOs are the Croatian Red Cross, the Center for the Culture of Dialogue, which is an NGO promoting rights of Muslims and interreligious dialogue in Croatia, the Croatian Academy of Legal Sciences, and the Croatian Academy of Medical Sciences. And each of the 4 NGOs appoints 2 persons who are directly implementing the monitoring activities by conducting 3 types of activities. So they are actually monitors, they are monitoring. And the 3 types of activities they are entitled to do are the following. First, they are entitled to announce and unannounced monitoring of the procedures and of the treatment of migrants and asylum seekers by police officers at border crossing points between Croatia and Bosnia and Herzegovina, Montenegro and Serbia, and in reception centers. Second, they're also supposed to do announced visits to the green border. And thirdly, they have access to finalized police files, which are based on complaints of illegal treatment of migrants and asylum seekers, as well as access to the activities and reports of the police directorate related to the reportedly illegal treatment, again, of migrants and asylum seekers. And they are able to be present during the interviews of migrants and asylum seekers, and they can inspect rooms where they are being held, where they are being interviewed, provided the interviewee agrees to this, and they will be assisted by interpreters when necessary. Now, within that year, they're supposed to conduct altogether 20 missions, and the Croatian Ministry of Interior is not part of the independent monitoring mechanism. It did establish the mechanism, but it is not part of it to ensure its independence. But it appoints a contact person for the purpose of enabling the activities of the independent monitoring mechanism and for providing the mechanism with statistical information and all the other information that is necessary. And the monitors, based on the information they gather, are free to choose the cases they want to monitor. And then they have to write individual reports within 7 days after each monitoring takes place. And they have to submit these individual reports to the coordinating board. And based on the monitor's individual reports, the coordinating board steers and manages the activities of the mechanism, and it writes the final report. And the final report will be, in the end, available to the public on the web pages of the Croatian Ministry of Interior. There is another board which is also supposed to be part of the mechanism, and that's the advisory board. And I still have not received the list of participants of the advisory board, but it has been stated that the European Commission and the Fundamental Rights Agency will be part of the advisory board, and that other organizations or bodies like the UNHCR, the Croatian Ombudsperson, and so on, will be invited or have already been invited to participate in the advisory board. Finally, I would just like to emphasize that I absolutely agree with Philippe that the establishment of this mechanism in Croatia can be really seen as a unique pilot project. As far as I know, this is, the first time something like this has been established in a member state. So I think from that perspective, it is even more important that it fulfills its role really well and that it serves as an example of good practice for similar mechanisms that might or will be established based on the proposal for the screening regulation if it gets adopted. Thank you very much.
Much, Iris. So we come to an end of this presentation, and it's now time to leave the floor to the audience for questions or remarks. In order to leave the possibility to as many persons as possible to take the floor, I kindly ask you to be precise and short in your question. And let's, as usual, start with the participants who are online to see if they have questions.
We have no questions online, so let's start by the questions here in Brussels. Does anyone have a question? Okay.
There is one question there on the right. Let's collect some questions, and then we will see who among the panelists wants to say something, and of course, again, very briefly to allow all of them or most of them to answer.
Thank you very much for this very interesting speech. And my question is about the legal procedure brought to the European Court of Justice against Frontex, because I think it's very interesting to find an action for failure to act against Frontex. But and I think that I understood that also certain articles of the EU Charter, of the fundamental charters, are bringing also to the attention of the court, probably as ad abundantiam arguments, not as a core arguments. But I think they are very important. But also, according to the charter, when the rights contained in the charter are the same of those contained in the European Court of Human Rights, the scope is the same. And last year, in the case of Georgia versus Russia case, the judge of the European Court of Human Rights, Pinto Albuquerque, put in a partly dissenting opinion how the Grand Chamber of the ECTHR is taking a less friendly approach to asylum seekers. And my question is if this can also drag to the European Court of Justice, which is now, I think, more amicable to this kind of cases, and if this is a worry that you may share or not. Thank you.
Let's collect some questions. That's a very difficult question. We have one more there. Yes.
Thank you all very much for the presentations. Very interesting. I would like to kind of zoom out from the accountability issue to ask your thoughts on how the public is responding to these numerous reports, complaints, investigations into Frontex. And I'm sure you will have heard of the latest civil society campaign, Abolish Frontex, which its demands are in its name, but they make connections between the military-industrial complex and racialized policing and Frontex, and generally opposing militarized borders. So given the budget of Frontex is set to expand to 1.4 billion by 2027, and you've spoken all a lot about the expanded powers of Frontex, I would like to know, how do you see that civil society campaign, but generally public opinions that that money could be better spent on everything from integration to search and rescue, generally a different, potentially less securitized approach to border management. Generally want to hear your response to that campaign. Thank you.
Very large question. Who else wants to take the floor? Nobody for the moment. Do we have somebody online? No? Hello, the technical team? Nobody. Okay, sorry, I couldn't hear your answer. So who wants to take one of those questions? First of all, about the legal action before the Court of Justice, and secondly, that broad question linking Frontex and the general, if I understood well, context about border controls. You want to start, please?
Okay, I start. Yes, on the broad question, indeed. I mean, of course, this is also almost a philosophical question, but perhaps something, perhaps we need to kind of look at the starting point. I mean, Regulation 656, which the colleague already mentioned, is about border surveillance, and our legal system, which has been the legal rules that have been adopted by a democratically legitimized Council and European Parliament, specify that crossings of borders happens at crossing border points, and this is not anything which is special to the Mediterranean or even the European Union, but this is, I think, a worldwide principle. You don't have the right just to walk over a border. So this is why you have border surveillance in place, in order to make sure that people come to border crossing points and where you can check whether they are entitled to enter. So that is the first point of departure. Now, of course, this is very difficult to implement on high sea with all the dangers that come with it, and this is exactly the very difficult work of Frontex. And I think everyone needs to appreciate this. This is not an easy job. This is very, very difficult. At the same time, they are there to implement European laws. And I think it is very unfair to kind of put them in a corner where they are almost treated as criminals just because they are implementing a legal mandate that they have received from the legislator. Now, of course, at the moment where boats are in distress, you have the search and rescue rules, and you have the international rules kicking in, and of course that prevails over border surveillance. But okay, let's not go into all the details, but I think it is important to remember that border surveillance is a legitimate task, and a task that has been given to Frontex by the legislator. Now, can the culture, can the money be spent better otherwise? I think it's not an or, it's not either you spend the money on border surveillance or you spend it on integration. I mean, you have to do both. You have to do border surveillance in order to keep out those that are not entitled to come to the EU. But of course, you need to spend money in order to integrate those that are entitled to come, and in order to, what was your second point? Yeah, search and rescue, of course. You need to have appropriate mechanisms in that sense in place. So, as I said, it's not an or in my view. And perhaps, if I'm already there, because there was a lot of talk about pushbacks and illegal pushbacks, and of course this is linked to what I just said. Not every refusal at the border is a pushback, but there are legitimate refusals of entry. And the art is to distinguish the illegal ones from the legal refusal of entry. And of course, there can be no question that the right to asylum, etc., have to be granted. But again, this is not as easy as it maybe looks from the outside, because it's not necessarily the case that everyone who comes to the border asks for asylum. And indeed, we have received many reports on incidents where these were qualified by the complainant as a pushback, but the complainant did not ask for asylum. Why? Well, for example, because she wouldn't want to ask for asylum in the country, the border of which she is crossing. And we know the Dublin system, you have to kind of go through the procedure in the country where you ask in the European Union for the first time for asylum. So there are many reasons. There is reason because there are traffickers involved, and these are criminals, and they rather prefer to escape a coast guard that they see rather than to bring the people and hand them over to the coast guards, because they would be arrested, because this is a criminal activity, trafficking in human beings. So there are many smuggling, and there are many reasons why, and therefore my only conclusion from all this, and sorry for being so long, is it's not as black and white, and one really has to look into the individual incidents, and this is what, as I said, the working group of the Management Board of Frontex tried to do earlier this year, and the report is online for you to check.
May I respond?
Yes, but I have to ask you to try to be very precise and clear, because it is a huge question.
It is.
So
Miss Ulrich,
go straight to the point.
Miss Ulrich said now something that is really unimaginable for me, that someone would ever engage in such a risky adventure, trying to reach the European coast without seeking asylum at the end. But this...
Sorry, but this is not the question. The question was about the Court of Justice of the European Union.
I thought that this is a debate and that I can respond to
if we answer into that, okay, you know, you will answer too, and then, no. So our rule is that you answer the question that has been asked.
Okay. So I guess that you referred to the Andy judgment, the notorious one from the Strasbourg court, and I can't say whether the Court of Justice is more amiable now to asylum seekers' right or not. The fact is that during the 17 years of Frontex operation, not once it was taken to court over fundamental rights violations, and this is a peculiar figure if you consider the nature of the activities of the agency. And the fact that predominantly the rights to asylum, the rights to life, the prohibition on refoulement, and so on are put at risk every day. We decided to do our best to end the de facto impunity, legal impunity of Frontex, notwithstanding the very restrictive jurisprudence of the Court of Justice when it comes to admissibility and to standing issues. We did it both because we have a good legal thesis, I think, and also because we can expect more from the European Commission, we can expect more from the Parliament, and we can also expect more from our courts when it comes to the protection of fundamental rights. And jurisprudence could and should evolve. So we decided to file the first ever legal action against Frontex, knowing that the jurisprudence of the court usually does not do justice to individuals, applicants that are not privileged one. If I may say, just like add two things, it is very difficult to hold Frontex to account for two reasons. First and foremost, it has always engaged in such non-transparency that it is quite hard to establish what it actually does at different stages of the operation. And second, again, what I said before, there are very few legal avenues available for individuals, for potential or already victims of pushbacks operations.
Thanks a lot. You accepted, because you sent us kindly the action for failure a copy, and you even told us that we can share it.
Absolutely.
So maybe we will send it per email to all the participants to this summer school for those of you who would be interested to read the factual part, but also the legal part. Now, may I ask the speakers who are with us online not to follow the example of the speakers who are on site, and to answer or make brief comments so that we have the time for a second round. Who wants to start? I cannot, actually you have to raise the hand and the technical team will tell us, or you open your microphone and you go ahead. Does it mean that nobody prefers, nobody wants to make a comment? I hope I hope that you all hear me. Otherwise, so at least say yes or show, make a sign, yes, you hear me. Okay. So is there a technical problem or is this a game?
I raised my hand in my case. There's a symbol there.
Okay, please go ahead.
I would not speculate by replying to the comments made by other honorable speakers for the simple reason that we as auditors cannot give opinions on other people's views. We are a fact-based organization, so obviously we can only limit our comments as to our own findings and not comments thereon. The points I would like to make is that there seemed to be, especially in the introduction, a bit of a gray area, which we came across in other meetings we had, to be fair to everybody, as to where the responsibility of Frontex begins or ends, and where does the member state responsibility begin or end. As I said, we did not audit the member states. We audited only Frontex's support to member states. But from our findings, there were at least 3 or 4 points which I think are worth keeping in mind. And these are the following, and I'll be as telegraphic as possible. Mention was made of the Eurosur framework. I think the responsibility for this to become more effective is Frontex's, not member states. Why? Because first of all, it needs to regularly assess the quality of the data used to produce the European situation and picture. Secondly, it needs to monitor and support member states in the correct implementation of Eurosur by establishing jointly agreed procedures to address identification shortcomings, which so far have been conspicuous by their absence. And I think after all these years of having so many mandates, especially now that they're working on a joint operational basis, I think that if we come to the need for establishing a common catalogue for reporting cross-border crime incidents, I think it's Frontex that should lead the member states and not the member states that should lead Frontex. We have to keep in mind also that Frontex was based or created on the basis, or the new mandate was based on a purely political decision taken at Council. So I think this makes it even more imperative that there should be evaluations periodically and regularly, as one would have in any organization, whether it's this type of organization or even in the corporate sector. You cannot have reports which are detailed, but which at the same time are not inherently evaluations or assessments. Anybody can write a list of activities. What we need is for these activities to be gauged, evaluated, assessed, and to see how effective they are in practice. My last point is of a technical nature, but it's something we came across not only in the questionnaire, but even in the member states that we visited. If Frontex does not take the lead to establish technical standards for equipment, we cannot blame member states if they are going to continue having a situation where, because of different technical border control equipment, there is a lack of interoperability of pooled equipment. The coordination, the lead on such an issue has to come from Frontex. Now, on the other hand, while I appreciate the points made by the Commission's representative, I think one should also underline the fact that even the Commission has its responsibilities. And I think that the Commission, rather than Frontex, should ensure that a complete European situational picture is available. And for this reason, we feel the Commission should explore new ways to achieve effective cooperation between Frontex and other relevant bodies to which Regulation 1896/2019 might not always be directly applicable. So in conclusion, I think these points, amongst others, which I don't have time, or I don't think I should delve into at this stage, justify the fact that in our case, when we came to make recommendations, we made recommendations to both the Commission and Frontex. And although, and I'm not being sarcastic or ironic, although it is positive to note that some recommendations are apparently being acted upon or looked at actively, as a rule, and this is for the benefit of people who might not be that familiar with the Court of Auditors, as a rule, whatever subject we may be auditing, it can be food waste, it can be climate change. I'm not talking of necessarily a sensitive issue like Frontex. Because many people, even when we address the national parliaments, told us, okay, we agree with your recommendations, but what happens with your recommendations? After 3 years, we look at things, we evaluate, and we see how effective they have been in the implementation. You may ask, why has it been a 3-year period? What determined that? Because if we try to follow up after 1 year, the agency involved, in this case we're talking of Frontex, it could be another agency, or even arguably the Commission, might bring up the excuse that they're still working on it and there's still a work in progress. A work in progress can be something which started yesterday or something which started 2 or 2.5 years ago. We think 3 years is a fair enough period for any organization, entity, including the Commission, that we are auditing to actually put their house in order. So this explains by when we expect our recommendations to be implemented, especially since all the recommendations were accepted. Because we have had instances in the past where we had reports where not all recommendations were accepted, either by the Commission or by the auditee agency involved. In this case, the fact that the recommendations were accepted by both the Commission and by Frontex puts a heavier onus on them, although it gives us satisfaction that they have been so positive in their reaction. And I must say, both Frontex and the Commission have been highly cooperative throughout the whole process, even if
Thanks a lot
of them. So I think I should put the record straight, and I'll stop here. Thank you very much for your attention.
Thanks a lot. Let's now have a second round of questions. We still have 10 minutes. I don't know if there is a football match tonight at 9 that some of you want absolutely to see. Tomorrow it will be, of course, with Italy, and all the Italians will certainly then leave on time. Do we have a question from the online audience?
No, there is no online question.
Okay, so let's then collect last questions. There are two questions there on my right side.
Hello, good evening. I have a very specific question for Professor Iris Goldner-Lang, because I know that you have written a lot on judicial passivism, so how courts do not try to act in certain political cases. And based on your knowledge of judicial passivism, how do you think that the Court of Justice will react to Front-Lex complaint?
I see that you follow what the Odysseus network and its members are doing. That's very good. Another question or remark?
Yeah, thanks a lot for the discussion. I would like to ask a question regarding the involvement of civil society in this debate, especially on the side of cities. For example, at the end of June, the city of Palermo and the city of Potsdam launched, together with other European cities, an initiative called From Sea to the City, where they have basically signed a document asking for the establishment of a search and rescue sort of civil service at a European level, and for it to be sponsored by the European Commission. So I was wondering, in its engagement with Frontex, what does the Commission think about the involvement of civil society? Thank you.
Okay, is there another question? It's the last moment that this is possible. Okay, no, it seems that everybody will be satisfied. So I leave first the floor maybe to the Commission.
Yeah, but this time I'll be short. Of course, I mean, civil society input is very important to the Commission, and I mean, you might know that we have very many mechanisms how this input can be provided to the Commission. Now, however, of course, we can make proposals, but in the end they have to be adopted by the Member States and the Parliament. So while we look at this input, of course, we have to see to what extent there is an interest and a demand from the side of the co-legislator to take a decision on this. You might know that there has been, since I think the Lisbon Treaty, the possibility of a referendum, no, not what is the right word? Yes, an initiative of a certain, of 1 million of citizens. Of course, that is a high threshold, but that is the tool that really kind of creates an obligation for the Commission to act. But of course, below this threshold, there is the question on whether there is a demand from the co-legislator. And now specifically on SAR, there is, I don't think at this stage, such a demand.
Thank you very much for that brief and precise answer. Iris, how are you going to overcome the challenge of answering briefly to the issue of judicial passivism that we invented together?
Well, I wouldn't dare to predict what the court is going to do. But generally speaking, I would say that, you know, the Court of Justice of the European Union has been very explicit when it comes to the protection of fundamental rights and the principle of non-refoulement. Just look at, for example, the MK that's the Strasbourg court, but still the MK case from Strasbourg, the FMS from Luxembourg, and so on. I would say that when the court wants to avoid answering the question by going into the merits of the case, it relies on procedural aspects. So it then simply says that, you know, for procedural reasons, it cannot go into the substance of the case by saying that the case is simply not admissible. So that's a possibility, of course. The other possibility is to simply to go into the substance. And I don't know what the court is going to do. And I don't think that the court would, you know, be afraid or silent when it comes to the protection of fundamental rights. I don't see it as such a court.
Okay, thanks a lot, Iris. Maybe everybody will not share that idea. We had already a debate about the answer of the court in the case X and X about humanitarian visas, where the court said that this is not covered by EU law, and this was actually the case on the basis of which we launched the debate of judicial passivism. Iftach has mentioned that the admissibility conditions in order to go to the court for a failure to act are quite restrictive. We will see what the court will do. Of course, if the court says it is inadmissible, then you will have critics about that. We will have then to see if it is online or not with its usual case law, or if it is just the implementation of the usual jurisprudence, even if it is restrictive. Very interesting debate again for lawyers, and I hope that we will have the possibility to discuss that at the 22nd, no, it will be too early, the 23rd, if not the 24th edition of the summer school. So come back or follow us online within a few years. So I want to thank all the speakers for having accepted to be with us tonight and to devote some of their time to participate in that debate. Thanks to all of you also, including the participants online, to stay so late with us. And tomorrow you start for the French-speaking group quite early at 9:30 with Professor Francesco Maiani, but I say this in English. Francesco Maiani is the best professor of the summer school. You know that we rate the professor of the summer school in the framework of the evaluation, and Francesco has almost 100% of positive evaluations. So if you speak French, follow his course that will be online, so you don't have to wake up that early. I'm sure that you would not be disappointed. And then we continue with other courses, in particular a course on databases, which is a very technical but interesting issue. And tomorrow a debate about legal migration, more especially about the blue card for highly skilled migrants. So I wish you a good evening and see you tomorrow.